Good afternoon, everybody. A very warm welcome to this latest Gowling webinar. Thank you for attending. This is the third webinar in our Scheme Sessions Volume 1 series. Over the last 2 weeks, we've heard from Louise Sivia of TPR and Sarah Horan of ITS in our first webinar, where we were looking at what's new in governance. Last week, we were joined by Margaret Snowden, and we looked at the particular issues around the new transfer regulations as a specific theme of trustee governance. And this week, for the third and final webinar, we'll be looking at governance basics in the context of the new single code, and in particular things like decision-making, recording decisions, and how trustees can keep themselves safe. Just a brief overview of the format of the session. So we'll be running from now till about 12:50 to 1 o'clock. I will be introducing our excellent speakers very shortly, and then we'll receive a presentation from them, and we'll have a bit of time for some questions and answers towards the end. You will find on your Zoom panel towards the bottom there's a Q&A box. So if you have any questions that you would like to ask, please fill those in and send those through the Q&A box. We'll endeavour to answer as many as we can, but if there isn't time, we'll also, if you leave your name there, we will come back to you separately after the webinar. All of the webinars, including today's, will be recorded, and therefore if you missed the previous two, you'll be able to catch up on those in your own time in the future. And shortly after this third webinar, we will be posting all those recordings. As always, there's some feedback that we'd be very grateful for at the end, which will pop up at the end of the webinar. Always really helpful to have your feedback on how we're doing and the types of topics that you'd like us to cover in the future. So that's all in terms of housekeeping. As I say, this third webinar is about governance basics, helping to keep trustees safe. Absolutely delighted to have two perfect speakers for the session. First of all, we have Nicholas Hill joining us. Nicholas is a leading pensions barrister from Outer Temple Chambers. As well as pensions, Nick specialises also in financial services and professional negligence cases, but in the area of pensions, as you'll see from what follows, Nick's a perfect person for us to have today. Nick's had a variety of experience. He's been instructed by TPR itself on proceedings. He sits on the litigation committee of the Association of Pension Lawyers and has appeared in very high profile cases such as the Lloyds case on GMP equalisation and the Arup case relating to indexation. So delighted to have Nick with us. And Nick is joined by our very own Charlotte Scholes. Charlotte is a very experienced senior lawyer at Gowling. She's one of the leaders of our pensions disputes pillars. And Charlotte's recently been involved also in some high profile cases which you will have read about, in particular the Mitchells and Butlers High Court case, which looked at rectification and also Britvic. So two perfect people for our session today, and therefore without further ado from me, I shall hand over to, I think, Charlotte, you're kicking off.
Thanks very much, Jason. Right, okay, well, thanks very much for joining this Back to Basics session. As the title implies, we'll be looking at the basics of good governance, and we'll also be looking at today's governance regime through the lens of the draft single code. And we'll be talking about some of the areas flagged in the guide and what that means on a practical level. Although, given timing constraints, we'll not be covering all of the code, but we'll just focus on these key topics. We'll split the talk into two parts. In the first part, we'll consider the journey to the current governance landscape, and we'll then move in the second part into practical tips for trustee meetings, meeting minutes, and managing conflicts. As Jason's indicated, there'll be the opportunity to ask questions through the Q&A function. So, first things first. Before we start talking about governance, it perhaps makes sense to consider the trustee body and the fundamental powers and duties that underpin its role. Now, when we talk about a trustee's role, one of the easiest ways to describe it, in my view, is by breaking it down into the following three components. You have the duties, the trustee's powers, and its roles and responsibilities. Now, I've included quite a lot in the final category for simplification purposes, But in my view, these are the core parts that make up the wider trustee whole. Now, this is quite a busy slide, but I've included to try and make it as comprehensive as possible. But you'll be pleased to hear I'm not going to read this out exhaustively, as I'm sure you'll be very familiar with the contents. But the real point here is that trustees need to be really clear on what their powers are, what their duties are, and all of the other roles and responsibilities expected of them. One of the fundamental pillars of good governance is having trustees who understand what is expected of them and are able to carry their duties and knowledge into effect. And as Nick and I are going to explain in due course, that includes knowing how to make trustee meetings as effective as possible, keeping a meticulous record of decisions, and ensuring that conflicts are identified and managed properly. Now, where things go wrong and complaints go to the Pensions Ombudsman, it is often because there's been a breakdown in the trustee's duties being carried into effect, or where there's been a fundamental misunderstanding about the nature of a trustee power. Now, you'll see on the slide, I've actually emboldened one of the duties listed above, not necessarily because it is the most important, but I just think in the context of governance, it is one of the duties that one needs to bear in mind. In case you're wondering why I've included an asterisk up here, this is why. The draft single code refers to the governing body rather than the trustees, and that's very much the language used in the draft single code. But the governing body is actually defined as more than the trustees, as it encompasses trustees or managers of occupational pension schemes, or in public service pension schemes, the scheme manager and the pension board. In other words, it's more of an umbrella term. So, what do we mean when we talk about governance? Well, when you boil it all down, we think it's about having a system to comply with the duties, powers, and roles and responsibilities. If you start with good people, because none of this stuff is possible without good people, then of course you need the right structures. By that I mean who is doing what and when, who is in charge of what. To be efficient and consistent and mitigate against risk, we need good processes. And finally, as obvious as it may seem, we need good understanding. And that really can mean two things. You've got trustee understanding, which in itself is a good understanding of its own role and having sufficient trustee knowledge and understanding. And I'll just pause for a second to explain trustee knowledge and understanding through the draft code. It means that the members of the governing body need to have a working knowledge of pensions. And in my view, this is no small undertaking. If you want to see the full list of what is expected of trustees, just take a look at the governing body section of the new code and pages 24 to 27. But it doesn't just stop there. It also includes good understanding about the members' own understanding of their rights and communicating that to them, and their understanding of their benefits, be that the investment options open to them or their ability to bring a complaint. And those are just two very basic examples. Now, if you get those things right, in our view, good governance is going to follow. And I should say, as I think I've alluded to already, that this is a very meaty topic. So we can't really expect to cover it all today. So we're going to just pick out some key themes. So we're going to pick out meetings and decision-making and trustee knowledge and understanding and managing conflicts. Of course, if there is sufficient interest, we'll be very happy to cover other topics in a separate session. Before we drill down into those areas in detail, though, I'm going to hand over to Nick to talk about how we got to where we are now.
Thank you very much, Charlotte, and I'm delighted to join in with this seminar. I really enjoyed the first two Gowling sessions, and it's been really interesting for me to think about good governance from my side of the legal fence, because of course so often when I get involved in cases, it's because something has gone wrong with governance and a mistake needs to be addressed in court. So thinking about the basics and how we might avoid that has been very, very helpful. So where are we now on governance? Well, of course, we're all here today really because of IOP2. And there was so much debate in the run-up to IOP2 coming to force, the UK's extensive lobbying on the Solvency II directive and whether the stringent funding requirements of that directive would make its way into IOP2. That was the focus of the UK government. My perception, at least, is the UK government was less concerned with some of the governance issues. But what IOP2 does is place much more emphasis on governance than IOP1. The governance requirements, as my second bullet point shows, extend to 10 articles outlining what comprises an effective system of governance. Now, of course, many of those governance requirements are already legal obligations of some types of schemes in the UK. And as a result, the government believes, and still believes, I think, that by making use of the proportionate approach available within IOP2, it can demonstrate transposition with, and I quote, minimal impact to industry. That was its stated ambition in 2019. And the IOP2 governance requirements, again, as I suspect we all know if we attended the first session, are dealt with through a mixture of legislative and non-legislative transposition. The governance amendment regulations came to force in January 2019, and they will be supported by the new code of practice. And I wanted just to pick out one little corner of the governance amendment regulations and how they have amended the Pensions Act 2004 on my second slide. Now, you may recall that Article 14.1 of IOP1 had required national regulators to ensure that IOPs had sound administrative and accounting procedures and adequate internal controls. The third and fourth words in the title to section 249A on my slide. What Regulation 2 of the Governance Amendment Regulations did was amend section 249 to require trustees, or rather governing bodies, of occupational pension schemes to establish and operate an effective system of governance, including internal controls, ESOG, as it's known. And note here, of course, section 1A, that the system of governance must be proportionate to the size, nature, scale, and complexity of the activities of the occupational pension scheme. So that was the major change, really, from a legislative perspective, brought about by the governance amendment regulations. And as we also know on our next slide, it was combined with the regulators' move to the single unified code. Regulators took 10 of their 15 current codes, the other 5 to be addressed in due course, created 51 modules that fall within the new single code. And I heard a fascinating speech by, I think it's Nick Gannon from TPR back in spring of last year, where he said that of the 10 codes that have been made into the new single draft code, they had found something like 53 or 54 pieces of guidance attached to them. So when I start thinking about the basics of good governance and how we get good governance right, it does strike me that the kind of spider web of regulatory material can at times feel really quite complex and overwhelming, particularly for lay trustees. And what I think the new code will do is make it easier to access, easier to understand, and easier to act upon. And Jason kindly mentioned in his introduction that I do quite a lot of work in the financial services context, including quite a lot of work for the FCA. In fact, back in 2009, I spent almost 6 months drafting FCA handbook provisions, as I'm quite familiar with how that works. And it may be I've gone a little bit native with my FCA work, but I think it works really well. I think the hyperlinks work really well. I think the time travel function works really well. I think it's a really helpful regulatory scaffold for authorised persons in that space to work from. But back to our journey and where we are now, what I do note just in passing is that the new code does include new material, my third bullet point here. New material on climate change, on cybersecurity, or remuneration policies, and so on and so forth. So whilst it was a bringing together of what's already existed, there's no doubt in my mind that there's a new emphasis on the requirements of good governance. And the two big changes, as this slide shows, are the new ESOG, and it's an extensive undertaking, must include processes and procedures to ensure compliance with 17 modules. And it's not entirely straightforward because it's a mixture of pure ESOG and legal obligations. And the quotation I have on the third bullet point is from David Fairs, one of the executive directors at TPR. And I absolutely agree with him that a user-friendly new code should make it easier and should help distinguish between legal duties and so on and so forth. But where I think the FCA handbook and indeed the PRA handbook is at the moment slightly more easy to navigate is that, of course, any of you who've looked at it will see the FCA handbook has rules, so requirements that must be complied with in the form of the secondary legislation, and guidance. Kind of it telegraphs the best practice for authorised persons to work from. And lots of the new code sets out requirements and then talks about best practice, but it perhaps isn't quite as clear in comparison to the FCA handbook. The other big change, again, I need to speed up, I'm mindful of the time, is the new requirement for the own risk assessment. Now, of course, that's not the scheme's usual risk assessment process by another name, although it takes into account those risks. It's an assessment of how well the ESOG is working and how well potential risks are being managed. So, in some respects, there's a renewed focus on good governance. Arguably, I think a new emphasis on good governance. There are some new requirements, but there is, certainly in my view, some really helpful assistance from the regulator. That's where we are now. I'm going to pass back to Charlotte to start looking at some of the specific good basic principles of governance in practice.
Right, well, as we promised you, here's the practical part. So I'm just going to transition over to starting off with the most basic thing of all, which is the meeting agenda. So how often should you be meeting? I'm sure many of you will be doing this already. The answer is, oh, hang on, I've moved ahead of myself. I'm dealing with the agenda first. The agenda should be circulated at least 2 weeks before the meeting, and it's expected that in most cases, the governing body would need to meet quarterly. What should be on the agenda? Well, I've listed out what should be covered, and it's very helpfully set out in the draft guide. Again, I won't go through this in detail, but for the purposes of info and being comprehensive, I have listed it all out. I have pulled out one point in particular, which is any decisions made since the previous meeting, because I think that this is actually quite an important point to record, because it's one that can potentially get easily missed. And I do think it's actually a bit of a risk management issue. So just a particular note to that. Moving next on to meeting minutes themselves. This is a question that we get asked about quite a lot: what should go into meeting minutes and what should be left out? Now, nothing in here is really rocket science, and for many schemes, you'll be covering all of this already. But it's worth noting that there are some additional expectations within the draft single code of practice. But again, one of the points I've emboldened here that's actually been in the guidance for a while is very, very obvious point, but the names of all in attendance. I'm just wanting to flag it now because I think with the dawn of virtual meetings, including virtual trustee meetings, there's a real danger that this doesn't get perfectly recorded, because particularly with Zoom calls or Teams calls, it is possible for people to drop in and out. And I think we need to be really clear on who attended the meeting. Did they attend for the whole of the meeting or in part? And were all the key decision makers always there at the right point in time? The next point I'm going to cover in the following slide is what should meeting minutes not cover. Oh, hang on, gone too far. Sorry, everybody. Right, and this is a point that again comes up quite regularly in practice, and it's a reminder to avoid the trap of inadvertently including legal advice in meeting minutes, which then results in a waiver of privilege in the legal advice to the trustee. And that will be because confidentiality in the advice had been lost when the minutes were disseminated to people other than the trustees. Now, just being practical here, if legal advice has to be contained in minutes, we suggest that you stick to the fact of the advice and attach a separate legal advice paper, and avoid putting any detail about the content of the advice in the minutes. However, if for some reason it's desirable to include the content of the legal advice in the minutes, our suggestion here would be that it's redacted before it's published on any member extranet or website, or if it's sent on to any third parties. I'd also suggest at this point that if any third parties are going to see the advice at the meeting, which I know is often the case, because there are often administrators and actuaries and investment consultants at meetings, then I think you really need to be seeking some kind of agreement, either in advance and in writing, ideally, that they will keep the advice confidential and they won't disclose it to anyone else. I'm aware that it is sometimes said that the requirement to keep the information confidential should be covered by the advisor's terms and conditions, but I think best practice here and good governance will be to ensure that each and every time a piece of legal advice is shared with them, that they agree. It can be, frankly, in a trade of emails, that they will agree to keep that advice confidential and they won't disclose it to any other parties. So I've already reveal the next slide, but I shall go back to it now. And this is another point that sometimes comes up in practice, which is what's the general rule of thumb when it comes for informal meetings as opposed to formal meetings? And I think the answer is pretty obvious, as we've already said, that formal meetings should always be minuted. And I'd also say that even if an informal meeting takes place, obviously notes should be kept of what is decided there. But it's just worth drawing to your attention the fact that there is a pragmatic approach being taken by TPO here. And in a determination in August 2020, the Ombudsman found that it wasn't maladministration for trustees not to have kept minutes, as the scheme only had 2 trustees and there were no formal meetings, and therefore there was no meeting to minutes in the first place. Now, that's quite interesting in terms of what it shows you about TPO's approach, although I perhaps should give a slight health warning attached to that, that was an exceptional case, but at least gives you an idea of the approach TPO might be prepared to take in the case of a very small scheme where there are only 2 trustees. Now, moving on to my next slide. I'm going to hand back to Nick at this point to talk a little bit about our next topic, which is decision making and giving reasons.
Thank you very much, Charlotte. So I start, here we're really thinking about discretionary decisions and the need to give reasons. And I start perhaps inevitably with the legal landscape. And then we're going to try and contrast that with some of the Ombudsman decisions in due course. And I've got 2 cases on my first slide. The first one is Wilson and Lord of Bencher. It's a decision of Mr. Justice Ratty back in 1994. And it's often cited by trustees with no small measure of relief when they're thinking about the need to give reasons. Because there, Mr. Justice Ratty said that in the absence of the evidence of impropriety, the court will not force pension scheme trustees to give reasons why they made a discretionary decision. Of course, what that means is that you needed, as a disappointed beneficiary, a prima facie breach. And in the absence of bad faith, that's obviously very difficult indeed. So that seems to sort of set the marker down that discretionary decisions are going to be quite hard to challenge. And that is, I think, broadly consistent with a very well-known Court of Appeal case called Edge and the Pensions Ombudsman, kind of a leading Court of Appeal authority from 1999. And there the court said, slightly different context, not quite so focused on discretionary decisions, but there the court said that it would only interfere with the trustee's exercise of discretion. And indeed, I note in passing here that the Ombudsman should only interfere with the trustee's exercise of its discretion if the trustee had disregarded relevant factors or considered irrelevant factors. And that's a phrase that's so often trotted out in the pensions cases. I remember in the Lloyd's GMP trial, someone, I forget it was the trustee or possibly even us or possibly the company, asked the judge, what factors should be taken into account by the trustee in making a particular decision. And Mr. Justice Morgan simply answered, take into account the relevant factors and don't take into account the irrelevant factors. And with the greatest respect to obviously an eminent High Court judge, it's deeply unhelpful. It doesn't really help the trustees at all. But the other reason the Court of Appeal gave an edge why the court might interfere with the trustee's discretion was if the trustees had committed any other procedural impropriety. And that really goes to the heart of good governance that Charlotte's been talking about. If you get your procedures right from the off in terms of your governance process, it's much harder for it to be challenged. And the third reason given by the court as to why they might interfere is if the trustees had taken a decision that no reasonable body of trustees, properly advising themselves of all the relevant circumstances, could have reasonably reached. So it's a very, very high threshold. But I think, respectfully to the Court of Appeal and indeed Mr. Justice Ratty, that it's not quite as clear-cut as it might seem at first glance. And on my next slide, I include a case called Scott and National Trust. And it's a fascinating read. It's actually an application for judicial review, all about a decision taken by the Council of the National Trust in 1997 to stop deer hunting on their land in Somerset. And it's a decision of Mr. Justice Robert Walker, as he then was. Mr. Justice Robert Walker would become, of course, Baron Walker of Gessingthorpe and be an eminent jurist in the Supreme Court 10 or 12 years later. And what he said, he looked at the minutes of the meeting, of the decision taken by the Council on the 10th of April. And he said the minutes of the meeting, which were no doubt drafted and considered with exceptional care, record there was a long discussion by the Council, but there are no details. This probably reflects a widely held view that trustees need not, and if well advised, should not give reasons. So far, so good. We're happy with that. It's consistent with Mr. Justice Ratty. It's sort of consistent with what the Court of Appeal say a year later. But the judge goes on, there is probably a lot of good sense in that, in the general run of cases. But, he says, The true position is as explained by Lord Norman in the Dundee Hospitals case. And you'll see from the quotation there that in that case, the appellants had argued that if reasons had been given, then there was greater liberty for the court to examine them and possibly to interfere. And Lord Norman said, in my opinion, that is erroneous. The principles on which the courts must proceed are the same whether the reasons for the trustee's decision are disclosed or not. But of course, it becomes easier to examine a decision if the reasons for it have been disclosed. So, of course, as with so often with judgments, that can be read in various different ways. It certainly doesn't suggest that reasons are required, but it also notes that it does not prevent the court from looking at decisions when claimants require it to do so. So that begs the question, I think, from our Back to Basics, Good Principles seminar, what best protects the trustee? Now, that almost certainly depends on the issue that they're making a decision about, whether it affects individual members or a whole cohort of members, for example. But practically speaking, it is always a challenge for trustees, or rather the governing body, to evidence reasons if they're required to do so, if there is no helpful contemporaneous documentation. Of course, the reasons may actually be cloaked in privilege, and then they have to confront difficult issues about potential waiver of privilege. And I have seen this quite recently, in fact, where there was no evidence of any reasons at all, which made it even more difficult to explain what we'd done in pre-action correspondence. And of course, if any time, let alone significant time, has passed, reconstructing decisions is difficult and obviously highly undesirable. So personally, I'm not convinced that not giving reasons necessarily best protects trustees. Moreover, and I'm going to hand back to Charlotte here, the approach of the Ombudsman does seem to suggest that reasons may be becoming more and more important.
Yes, Nick, that's absolutely right. You know, as you've demonstrated, there has been a bit of a shift in the case law over the years, and obviously, for the sake of brevity, you'd be pleased to hear we've kept the body of case law to a slim number, but there are some more cases showing the gradual movement towards giving reasons. But it's all very well hearing about what the courts think, but no disrespect, Nick, what's more important is what the Ombudsman has to say, because ultimately, if members are going to bring complaints, they're going to be going by and large to the Pensions Ombudsman rather than going to court. So what has the Ombudsman had to say about this? Well, I've pulled out a few examples here, and I'm going to speak about a couple of these cases. One case which I really have to mention in this context is Dr. G. Some of you may have heard about this case already. Apologies, because I am going to recap on the facts. But it's a pretty important case. The fact pattern is pretty similar. Pretty simple. I'll just go over it now. Dr. G was the partner of Mr. T, and following Mr. T's death, AJ Bell had to consider whether to award Dr. G some discretionary death benefits. Dr. G and Mr. T had lived together and jointly owned their house, albeit Dr. G only owned 10% of it. And it was Mr. T's second marriage, and under his will, the majority of his assets were left to his children. And AJ Bell decided that Dr. G shouldn't receive any death benefits. Instead, they decided that these should go to Mr. T's children. Now, the minutes of the meeting, which AJ Bell decided what to do, did actually detail what factors they took into account. But this wasn't enough for the Pensions Ombudsman. He said that AJ Bell had to explain why they reached their decision, and moreover, that explanation needed to be documented in the minutes and communicated to Dr. G. And as it had not been, it was not possible for him as the Ombudsman to establish whether the discretion had been exercised appropriately or not. It was vital, he said, for sufficient reasons to be documented, which conveyed an understanding of the factors which are being given weight and the factors which are being discounted. And that was to enable the aggrieved party, so in this case, Dr. G, to know whether there might be grounds to challenge the decision. And what he actually said was, as quoted on the slide, that the reasons didn't really need to be lengthy, but they should just be sufficient to basically allow the aggrieved party to know if they had any grounds to challenge the decision. And so in that case, he ordered AJ Bell to reconsider their decision and to document the rationale for it and then communicate that to Dr. G. And as I've indicated, this is not just a one-off case. This is a 2018 case. There have been other cases, and another one of the cases referred to on this slide, the Mrs. D case, is also quite helpful at indicating TPO's likely approach. And it really, this particular case touches more on the investigations into the potential beneficiaries when a death benefit is payable pursuant to a discretion. And it really just emphasises the fact that discretionary decisions need to be rigorously recorded. So this was another death benefits case where the decision-making process was attacked as being procedurally unfair. Mr. D died in May 2017, and at the time he was married to Mrs. D, but he'd separated from her and he was now with Miss Y. And Mr. D's expression of wish form was in favour of Mrs. D, but later wills indicated he wanted Miss Y to be provided for as well. And in this case, the discretionary decision was taken in favour of paying all the benefits to Miss Y. And in the minutes, it was recorded as follows: pay to partner as she has financial dependency, and policyholder will shows he intended for her to benefit from his pension policy. Expression of wish form disregarded as it was for his former wife. Now, Mrs. D wasn't very happy about that, and she complained that she'd been nominated on the expression of wish form and she was also financially dependent. And in that case, TPO said that basically the decision-making had been procedurally unfair. And that was because it was partly unclear from the record of the decision what weight, if any, the decision makers had given to the extent of Mrs. D's dependency. They had also made other mistakes, but I'm going to just, for the sake of time, not get into that. But basically what TPO said was he required Phoenix Life to go back and take the decision again and record what it had done and the decision, the factors that it had regard to and those that had discounted. And he made it very clear that his role wasn't to substitute his decision in their place, and that in making the direction he did, he wasn't intending to express any opinion as to the appropriate distribution of that benefit. So what do we take from these cases, and what helpful tips can we give you? Well, this is what I've tried to set out on the next slide. Sorry, I'm being so incompetent with these. Right, so some practical tips, and I'm aware of the time, so I'm going to be relatively light touch, but hopefully these are helpful. Obviously, consider the financial circumstances of all potential beneficiaries and explore financial dependency. Now, that may sound really, really obvious, but I think you really need to ensure you test the evidence here and make sure that what's been provided really does show dependency, because I'm not sure that it always does. You also need to make suitable inquiries, but they don't need to be absolutely extensive. You don't have to go to the ends of the earth. They just need to be appropriate to the circumstances of the case. You also need to obviously keep a really detailed record of the investigations. What do I mean by this? Well, what I mean is who was contacted and when, what information do they provide, what do they not provide, and keep a record of the review of the evidence and record all the decisions that are made. As I've set out, obviously recording the reasoning, I'm not going to go on about that, you get the message. But basically you should bear in mind the words in Dr. G, that you should be giving sufficient reasons to enable the aggrieved party, so somebody who doesn't get awarded the benefit but has ultimately been considered in the general course of beneficiaries, you need to give them reasons as to why the award wasn't made in their favour. Now, these decisions do raise interesting questions as to whether this approach would be adopted when it comes to all discretionary decisions. There isn't room to talk about that right now because I need to hand over to Nick to talk about conflicts, but maybe that's a subject to revisit in due course.
Thank you very much, Charlotte. I'm also conscious of the time, and I see there are lots of questions coming in, so I'm keen to leave some time for questions. So I'm going to try and take conflicts a little bit of a whistle stop. I'm going to talk about two kind of broad themes with conflicts. The first one on this first slide is really to look at conflicts, why they exist, how they exist, and why they're so difficult to deal with. And then secondly, I'm going to make three observations that really intended to assist with managing conflicts, because of course identifying conflicts and monitoring conflicts may not be that tricky. The tricky bit often is how you actually manage the conflict in due course. So first of all, my whistle stop reminder of conflicts. I'm going to gloss over Reed Thompson and just highlight the fact that there was a recent High Court case that grappled with conflicts and pension schemes in the form of Keymed and Hillman. a decision from 2019 of Mr. Justice Marcus Smith. It's a fascinating case. And in fact, there's an excellent seminar I saw from Gowling, in fact, on this case, which I'd recommend to anyone in due course. But it's a case where the court dismissed a claim by a company against 2 of its former directors, in which the company alleged that the defendants had abused their positions as directors. The company's case was that the directors had acted against the company's interests by, amongst other things, setting up an executive pension scheme of which they were the trustees, then using their powers as trustees to maximise their own benefit by, for example, I think disapplying inland revenue limits, providing benefits for spouses, and following a very conservative, or it might be said prudent, and therefore very expensive, investment and funding policy. It's a really interesting case where the court has to grapple with conflicts at a really quite obvious level. And Mr. Justice Marcus Smith said in paragraph 33, it is inherent in the nature of pension schemes that there is an enormous potential for conflict between the interests of the members of the scheme and the interests of the employer sponsoring the scheme. And the inherent nature of that conflict is so obvious, of course, that there is statutory intervention for pension schemes in the form of Section 39 of the Pensions Act 1995. That effectively excludes the rule on conflict from applying to the exercise of powers by trustees, merely because they will benefit from the exercise of that power. And the conflict stems from the general rule that trustees, like all fiduciaries, must not place themselves in positions or enter into transactions where there is or may be a conflict between their duty as a fiduciary and their personal interests or their other duties. And that's because of their obligation of loyalty on a fiduciary. And there's a lovely line from an old case called Costa Rica Railway and Forward, where the courts explain that the basis for the rule is not morality, but rather a practical one, that being the fallibility of human nature. And I was once able to placate an irate finance director who I told couldn't take part in a decision because of a conflict by pointing out it was nothing to do with him, it was simply about the nature, the fallibility of human nature. And my third introductory observation here is to note that I don't think conflicts have a hard edge. I think the reason why conflicts are so difficult is because they have to be very carefully considered in the particular circumstances of the particular individuals involved and the particular scheme. And that does reflect the case law. It's a case called Boorman and Phipps from 1966, where the court said that the question about conflicts is whether a reasonable person, looking at the relevant facts and circumstances, would think that there was a real sensible possibility of conflict. Of course, the word sensible there is doing an awful lot, which rather illustrates how difficult conflicts can be to identify and manage. My next slide recommends wholeheartedly the TPR approach to identifying, monitoring and managing conflicts. And this is from some of the guidance on the TPR website, you'll see it there. It always seems to me that if we just always have this guidance in mind, 3 steps, identify, monitor and manage, many of the problems with conflicts may be resolved. And looking a little bit more at identify, the best conflict management policies I've seen on trustee boards nearly always start with a kind of a preamble or recital that says that all members of the trustee board will be entirely open and transparent about conflicts, possible conflicts, any issue that anyone might perceive as giving rise to a conflict. And you start with that open and transparent approach and everything becomes much easier. So a cursory reference to conflicts at the start of a trustee meeting, it may be sufficient, depending on the size of your trustee board and who's involved and so on and so forth, but it may not. Again, think about identification. When did you last discuss with any director of the company who's on the governing body when he last grappled with section 175 of the 2006 Act, the Companies Act? What about a trade union representative who's on the trustees governing body? Might he or she be conflicted by virtue of his or her particular focus on, for example, trade union members, or indeed simply active members as opposed to deferred members? And what about advisors? No doubt you thought about conflicts when you appointed your advisors, and no doubt the obligation is on your advisors to think about conflicts going forward. But when did you last check with your advisors about conflicts? So identification is important. And the second step on my next slide is about monitoring those issues. And I say rather grandly, and probably you might say quite unhelpfully, that we should aim to perfect processes. Because with conflicts and conflict management, you need to do the basics really, really well. You need to understand TPR's requirements, TPR's guidance, and you need to implement it. You need a very clear and full conflicts register that's up to date. You need to make sure all interests are declared. You need to think about how you grapple with different types of conflict. Might you describe some of them as material or trivial or non-trivial? And as Charlotte's already mentioned in the context of decision-making, you need to use the minutes. When you've identified a conflict, it's no good just to say the trustees discussed conflicts and were satisfied. That isn't sufficient, given the potential consequences, i.e. trustees may be found to have been in breach of trust if decisions taken in breach of the conflict rule. But thirdly, and finally, before we open up for questions, I wanted to talk a little bit about managing conflicts, because that's where I think TPR guidance, perhaps inevitably, a little bit less helpful, because of course it's very hard, there's no one size fits all. And I identify 4 possible solutions to what I call the management challenge. When you have a conflicted trustee director, one option, my first bullet point, is that that trustee director resigns and is replaced on no doubt, a particular issue. They're replaced by new directors not involved in company decision-making on that issue. Now, of course, you'd have to make sure that your replacement trustee board complied with any minimum number requirements and indeed NMT or NMD requirements. And the great problem with resign and replace is that you lose the benefit of whoever the conflicted director is and their knowledge on other non-conflicted scheme matters. But it's clean and it's unarguably effective, unless, of course, the decision-making process has already been infected by that conflict. The second bullet point I identify is the possibility of abstentions, that the conflicted trustee board directors abstain themselves from meetings at which the issue in question is being discussed and abstain from voting on the matter. Now that must, of course, be permitted by the scheme rules or the trustees' articles of association so that decisions can be taken by majority vote. And you must make sure you satisfy any quorum requirements. But it's a possibility. I flag up in passing, and not for discussion now, a fascinating report from TPR under section 89 of the Pensions Act 2004 about the Hugh Mackey retirement benefit scheme. It's a case that I've had to speak about several times because the trustee in question there was prohibited, was a Mr. Hill with 2 daughters who was horribly conflicted and sold commercial property to the trustees in breach of various duties to profit himself. Well, I am not the same Mr. Hill, and for the one who's found out, my daughters are 6 and 4 and don't earn any commercial property. But nonetheless, what the Section 89 report tells us there is that in that case, of an acute conflict, simply leaving the room during meetings, as Mr. Hill had claimed he had done, was no way near sufficient. He was acting on both sides of the transaction and negotiating with himself. So abstentions, abstaining, it's an option, but it may not be sufficient. The third option on the list, and the one I strongly prefer, is delegation, where the conflicted director steps aside and the matter is delegated to a subcommittee. All conflicted persons must be excluded from that subcommittee, and indeed from the trustees' decision-making on any negotiation, but they can continue to participate in other trustee and scheme matters. It's a kind of a formal version of abstention, which in my view works much more effectively. It's much better for managing kind of perceptions of conflict, perceptions of the decision-making process, and indeed it's much better for creating a paper trail to show what the trustee has done to manage that conflict. The other benefit, of course, is that it doesn't trigger the NMT or NMD implications. You have no concerns about quorum, and the trustee board retains the benefit of the particular conflicted director's experience and knowledge on other scheme matters. And then my fourth and final point before I hand over to Jason is entirely self-interested, and which is where I say that you should remember the possibility of an application to court. The court has an inherent jurisdiction to preemptively authorise a trustee to take action that would otherwise be in breach of the rule against conflict. That might be better described as preemptively declaring that a particular transaction, as authorised, is fair and reasonable and that cannot be set aside. Fair and reasonable is the language of some of the older case law. And within court authorisation, I should identify the ultimate last resort, which is that the trustees can seek to surrender their discretion to the court in the sense of Public Trustee in Cooper 2001 case. The courts are very, very reluctant ever to accept that surrender of discretion, but it is an option open when you're thinking about how to manage conflict. And with that whistle-top thoughts on managing conflict, I'm going to pass back to Jason, and I'm very keen for Jason and Charlotte to answer any difficult questions that you may have for them.
Oh, you're so kind, Nick.
Thanks, Nick, and thanks, Charlotte, for a great presentation. Pensions Ombudsman stuff's always interesting, and but I always find when I've got Mr. G and Mr. T, I can't get away from thinking about Sacha Baron Cohen or showing my age, the A-Team.
Yeah.
But we got lots of really good questions, so let's get cracking into those if we can then. So, Charlotte, perhaps I could just start with you. We've had a question that's sort of around the duty to give reasons point.
Yes.
So on a sort of death benefit case where a number of beneficiaries have been considered, are we saying trustees have to go as far as writing to each potential beneficiary to explain whether they got something or they didn't get something?
Well, I think the answer is this is all a matter of calculated risk. And obviously what I have outlined in terms of TPO's stance to giving reasons just sets out TPO's likely approach in the circ. So it's going to be a matter of judgment for every set of trustees. But I would say counsel of perfection is that, yes, they should be writing to beneficiaries. They shouldn't be waiting for the beneficiaries to query it. I think if they've got they've asked various individuals to submit information, for example, showing evidence of financial dependency or showing why they might be in the running to get some of the award of the death benefit, then yes, I think they should be giving them reasons.
Thanks, Nick. Anything to add?
No, I mean, not really. I think it's an interesting question. I suppose I was wondering about that's a case where, of course, you know who you're dealing with. There does seem to be a new interest in the court's jurisdiction, what's called a re-Benjamin order, which is where trustees are grappling with decisions about distribution of assets, and they are concerned that they have not, for whatever reason, identified all the potential beneficiaries, and concerned about a claim for breach of trust in due course. And there's what's called a re-Benjamin order. I think you make it under Part 64 of the CPR, where you go to court and say, this is what we're planning to do, and this is why, and you get the blessing of the court for that particular distribution. It's a different point, but there is this new, I think, awareness of the complexities of modern pension schemes and needing to protect the trustees as they take really quite difficult decisions where there's quite often no right answer.
Yeah, thanks. And I mean, I guess it's also the issue with the potential beneficiary cases. You have to be particularly careful not to be sort of revealing things about other people. So a careful balance to be met, I think, as ever, as you've explained before.
Yeah, absolutely.
And just a couple of other questions which start to get down into an interesting area, which is, we're all seeing a trend towards professional trusteeship and moving on from that, sole professional trustees. A couple of questions that I think sort of come out of that would from the audience. So one is, given that sort of change and the way that trustee boards are operating, do we think that the idea of a quarterly trustee meeting, as it were, is a bit sort of old hat, and actually we should be recognising that things are much more fluid, and does that lead to any governance issues? Charlotte?
Well, it's an interesting one, Jason. I mean, I think I would view it as meet no less than that. I would have that as a sort of bare minimum benchmark, but I think there's been comments around boards needing to be flexible. And clearly, if business or if there's a business need or a trustee need to meet more regularly than that, to consider extraordinary business, then I think definitely they should be open to that. This isn't ultimately a tick box exercise. I think we have to be really clear on that. There's a lot in the draft single code, but it's not about box ticking. You really got to sort of think about the whole management and governance of the fund in a holistic manner.
Yeah, no, absolutely. I totally would see that. And I think, Nick, if I can sort of take you to the other question we had around this, perhaps, which picks up on what Charlotte had raised in the PO determination, it's sort of a suggestion from that particular case that, if there were two trustees, formal meeting minutes weren't required. And if you take that to an extension of the sole professional trustee, it's almost suggesting that there's some kind of lower threshold there, which can't be right, can it?
It can't be right. And also, I think a sole independent trustee would be mad to take that approach, simply because they need to protect themselves. I mean, that Ombudsman decision, Charlotte sent me a copy of it and told me she was going to mention it in the talk, and I was sort of stunned by it when I read it, because it was an exceptional case, a really exceptional case. But it should absolutely not be taken as a rule of thumb that that's an appropriate
No.
thing to do, particularly with the sole trustee. The standard doesn't shift. It's just on the particular facts of that case, it was deemed by the Ombudsman benevolently to be permissible. But no, I don't think the standard shifts at all. If anything, I think if there was a sole trusteeship, I'd demand even better, really, records of that governance, because they only need to deal with themselves, if that makes sense.
Yeah, absolutely. Charlotte, anything to add to that?
No, nothing more. I mean, I suppose it's the old, sorry to say, it's the old lawyers sort of get out of jail card. It always very much turns on the facts of every individual case and on the, the size of the fund, crucially. This Ombudsman determination was an extremely small scheme. So I think that's why it's so exceptional. But I suspect, I don't know exactly who the question came from, but I suspect the schemes that generally most of the participants on this call will be dealing with will be of a sufficient size that not keeping a record of meetings or not having formal meeting minutes is just a complete no-go.
Yeah, I think from my experience talking to the professional trustees out there, I don't think anyone will be falling into this trap. But the what people shouldn't confuse, it seems to me, is the sort of opportunity for efficiency through sole trusteeship, and then
Absolutely.
sort of lessening governance around that. And as I said,
I agree with that, and TPR does place much more focus, as does IORP2, on proportionality. So
yeah.
I think there's a balance to be struck, isn't there? But absolutely, you can streamline your processes and be proportionate as long as you're making sure your effective system of governance is in place. That should be a cost saving, in theory at least.
There's one other topic that sort of come up in questions that we sort of is linked, but we haven't covered, but just maybe we've got a minute or so on that, which is record keeping and the amount of time that people, trustees, keep records for, what type of records they keep. Any sort of high level guidance on that for the audience? Charlotte, maybe start with you.
Yeah, sure. I'm really happy to deal with this one, Jason. Thanks. So this is a question again that, thanks for raising it, it does come up a lot in practice. People often ask how long should they be keeping records for? Well, I suppose my answer to that is it rather depends what records you're talking about. I mean, TPR is clear that member contribution records, for example, should always be kept for 6 years. But if you take at the other end of the spectrum, keeping the scheme's governing documentation, I would say you need to keep it for the entire lifetime of the scheme and possibly another 12 to 15 years post wind up. And in terms of member data, I've also heard it said that really you should be looking to keep that for 15 years post wind up. Again, because you never know what claims could arise post wind up of the scheme and what challenges may come up. And if you've got rid of all that data, it's going to make it pretty hard to deal with those challenges. And I'm aware that sometimes there are situations in which schemes have wound up and it's actually the solicitors that become, custodians of, for example, the scheme governing documentation.
And that's consistent, Charlotte, actually, with Oprah's guidance, as it was pre-TPR world, that they said in schemes that are well governed, we often see scheme documentation held for the entire lifetime of the scheme and beyond the lifetime of the scheme. And also, just thinking about it practically, I spend some of my time dealing with rectification cases. I was in a case called about the Igesund pension scheme last year, where we wanted to rectify the scheme because the indexation power had been accidentally changed to omit a power to switch. So potentially a valuable power that had been lost by accident. And the most powerful piece of evidence we have for the rectification that Chief Master Marsh said made this an open and shut case was that the particular trustee on the subcommittee who'd been delegated to deal with the consolidation had kept really detailed notes. And his notes had referred to the new rule on the indexation power, and he'd written same old indexation power, evidencing very clearly contemporaneously that he had no intention to change it. And he had kept those notes in the filing cupboard in his garage in the Lake District, and they were invaluable. So I'm a big fan of retaining scheme documentation as long as you can justify it, pursuant to GDPR and so on, well in excess of 6 years. And that's where you need to look at different types of data quite carefully. But I'm a big fan of it because it makes rectification so much easier.
Great news for all those hoarders out there.
Yeah.
Absolutely. Thanks, Nick. Thanks, Charlotte. I'm conscious of time. We are just approaching the end of our session. Thanks both of you for a great presentation and answering those questions as well. Thanks to everyone in the audience for being with us. and for raising those questions. If you do have any other thoughts or questions that occur to you, please feel free to contact us separately, and we'd be very happy to pick up your questions then. If I could just remind you, if you do have a minute just to complete the feedback form, when that pops up, we'd really appreciate it. And thank you again to Charlotte and Nick for a really useful session, giving people plenty to think about. And that has been a perfect way to bring an end to our series of 3 webinars on the topic of governance. As I said at the beginning, we will be issuing the recordings of all 3 of the webinars, so you can catch up on the other 2 and indeed share with colleagues this one too. So thanks very much, Charlotte, Nick, thanks to all of you, and have a great afternoon, everyone. Cheerio.